In the appeal, Jessy Prix against the Secretary of State for Work and Pensions.
Jessy Prix is a French woman and qualified teacher who came to the United Kingdom in 2006. She worked in various jobs, mostly as a teaching assistant, for nearly a year. Then she enrolled on a course leading to a postgraduate certificate in education. But she became pregnant and realised that her child was due to be born before the end of her course. So she withdrew. She then took agency positions working in nursery schools. By the 12th of March 2008, she was 6 months pregnant and found the demands of looking after such young children too strenuous, so she gave it up. She looked for lighter work, but none was available. So, on the advice of her doctor, she gave up looking and made a claim for income support. Had she been a UK citizen, she would have been entitled to it, as she was now within 11 weeks of her expected week of confinement. But her claim was refused because she was a, quote, person from abroad, end quote. Her baby was born on the 21st of May 2008, and she returned to work 3 months later. However, the regulations provide that a European Union citizen is not a person from abroad if she falls within Article 7 of the 2004 Citizenship Directive. Article 7.1 covers a person who is a worker or self-employed person. Article 7.3 provides that certain people retain the status of worker even though they are no longer in employment. These include people temporarily unable to work because of illness or accident, but not a woman who ceases work because she is in the late stages of pregnancy or the immediate aftermath of giving birth. The appellant argues that under EU law, a broad interpretation is given to the term worker. It does not necessarily depend upon the continuing existence of an employment relationship. It would be a substantial deterrent to the free movement of female workers and amount to direct discrimination on grounds of sex if they lost the status of worker around the time of giving birth. The respondent argues that Article 7 was intended to be a codification of the existing EU law on workers, and women in the appellant's position fell outside it. Any discrimination was on grounds of nationality, was indirect, and was justified. The Supreme Court is not persuaded that the argument of either side is clearly right. It is therefore under an obligation to refer the case to the Court of Justice of the European Union in Luxembourg for an opinion. The directive may have codified the law as it then stood, but this did not necessarily rule out further development of the concept of worker in line with the fundamental principles of EU law. Pregnancy and the immediate aftermath of childbirth, as opposed to leaving the workplace to look after children, are a special case, affecting only women who will suffer comparative disadvantage in the workplace unless special account is taken of them. Equal treatment of men and women is one of the fundamental principles of EU law. The following questions are therefore referred to the Court of Justice. 1. Is the right of residence conferred upon a worker in Article 7 of the Citizenship Directive to be interpreted as applying only to 1. Those in an existing employment relationship, 2. At least in certain circumstances, those seeking work, or 3, those covered by the extensions in Article 7.3? Or is the article to be interpreted as not precluding the recognition of further persons who remain workers for this purpose? 2. 1. If the latter, does it extend to a woman who reasonably gives up work or seeking work because of the physical constraints of the late stages of pregnancy and the aftermath of childbirth? 2.2. If so, is she entitled to the benefit of the national law's definition of when it is reasonable for her to do so? The Court will await the opinion of the Court of Justice of the European Union with great interest. The Court will now adjourn.